Cambridge Analytica, on the other hand, gave an initial response that data of Indians was not breached, but this was not in conformity with what was reported by Facebook. Cambridge Analytica also did not respond to the subsequent notice.
Please silence.
Therefore, it is suspected, Chairman Sir, that Cambridge Analytica may have been involved in illegally obtaining data of Indians which could be misused. The government has entrusted the issue to be investigated by the CBI for possible violation of Information Technology Act 2000 and Indian Penal Code. There were also subsequent reports that data of users were illegally accessed by hardware manufacturers who had tie-up with Facebook. In this regard to this issue, Facebook has reported that they are not aware of any misuse of Facebook information, including Indian user information. The Chairman said the other series of incidents relating to abuse of social media where mob lynching were reported in various parts of the country, consequent to circulation of wild rumors on WhatsApp, as a result of which innocent people have lost their lives. The government swiftly issued notice to WhatsApp, since in most incidents, such horrible events were preceded by viral circulation of rumors on this platform. In response, WhatsApp have taken steps to increase the friction in propagation of content on the platform by reducing the number of forwards to 5 and also indicating whether an income message is either forwarded or originally composed by the sender. They have also planned to remove the forward button that appears adjacent to the video or audio message. They have also informed that they will be bringing in fact-checking and fake news verification mechanism to help people check the veracity of the content on the platform. While taking note of such response, Mr. Chairman, sir, it was felt it was not adequate to meet the challenges of the situation. Therefore, WhatsApp has been asked to come out with better technological solutions so that misuse of the platform is avoided. Also, the government has issued second notice to WhatsApp, and it was conveyed to them at the highest level that being a technological major company, it is equally their responsibility to promptly come up with technical solution when a harmful message is in wide circulation on the same day in a particular area on a particular issue. It is their obligation to inform the law enforcement agencies when they notice such virtual messages. Now, sir, I come to the action taken by Ministry of Home Affairs. The Ministry of Home Affairs has issued a number of advisories, including one advisory on untoward incidents in the name of protection of cows, dated 9th August 2016, another advisory on cybercrime prevention and control, dated 13 January 2018, and also an advisory on incidents of lynching by mobs in some states, fueled by rumors of lifting kidnapping of children, dated 4 July 2018. Pursuant to the direction of Supreme Court order dated 17 July 2018, MHA has issued a directive to the states for implementation of the directions of the Apex Court on 23 July 2018 and has constituted a group of ministers at the high-level committee to make recommendations in the matter. Now, sir, I come to the legal provision very briefly. One is the IT Act 2000, provision for blocking and removal of content. Blocking of website information. Section 69A of the IT Act provides for blocking of websites, web pages in specific conditions: defense of India, sovereignty integrity of India, security of the state, foreign relations with foreign states, public order, or preventing or incitement to the commission of any cognizable offence relating to above. B. Disabling or removal of information by intermediaries. Social media sites, intermediaries are required to disable or remove any unlawful information as and when brought to their knowledge through a court order or by through appropriate government or agency. Various law enforcement agencies notify the social media sites for removal of contents, disabling of contents under provision of Section 793B of the IT Act 2000. The IT Intermediary Rules 2011 notified under Section 79 of the IT Act requires that the intermediary shall observe due diligence while discharging their duties and shall inform the users of computer resources not to host, display, upload, modify, publish, transmit or update, share any information that is harmful, objectionable, affect minors, unlawful in any way. Now, sir, I just share with this House how many blockings we have done under Section 9A of the Act. Sir, for Facebook, we have blocked 457, for YouTube, 95, for Twitter, 321, for Instagram, 41, others 51. The compliance of intermediary in the year 2018 till June 2018 as follows, sir. Facebook 499, YouTube 57, Twitter 88, Instagram 25, Tumblr 28. URL means, sir, Uniform Resource Locator. The legal provisions that are currently available with regard to the conduct of intermediaries, which includes various social media platforms, in order to respond to such development are in the IT Act 2000. Some of such provisions need to be revised and reinforced so that they can respond to the emerging challenges. This is proposed to be done by strengthening the implementation aspect under Section 79 of the IT Act 2000. Now, sir, Honorable Chairman, sir, I come to a new measure which the government is proposing to take. It is critical for social media service providers regulated as online intermediaries under Indian law to ensure that the lawful provisions of their services and platforms in India, in order to continue to receive access to Indian users, should ensure and demonstrate the strict compliance with the IT Act as well as all other applicable laws, as well as submit themselves and their services, platforms and other applications to the jurisdiction of Indian courts and authorities by having a physical presence in India. Next, to continue to target Indian users, such intermediaries must implement appropriate legal measures and assist in curtailing any use of such services and platforms that perpetuate harm in Indian society, including loss of life or disruption of public order. This, at the very minimum, necessarily requires them to ensure that all such malicious messages circulated through their services or platform in India can be traced and their source of origin be effectively identified by law enforcement agencies or relevant public authority. Next, the government is therefore seriously considering that through appropriate rules, all social media platforms should be required to locate their grievance officers in India who could act as the point of contact for all communication with regard to such grievances. The duty of such grievance officer should cover not only to receive grievances on real-time basis, but also to inform law enforcement agencies. It is planned to issue directives in public interest to such intermediary that would require all such social media platforms to ensure that their platform do not become vehicles for promoting hatred, terrorism, money laundering, mob violence and rumor mongering. They should provide for technological solutions so that verified fake news and provocative messages can be filtered by technical solutions. They should bring in a more effective mechanism receiving grievances, and they should report to the law enforcement agencies. They should also seek to provide the facility of verifying fake news on the platform itself. Next, further, this government will strengthen the appropriate legal framework to ensure that significant social media and instant messaging service providers targeting Indian users do not deprive Indian users of the right to bring proceedings in India and of the protection of Indian law. Next, the government wishes to make it very clear that social media platform run by any company or entity is an important stakeholder, and therefore it cannot evade its responsibility, accountability and larger commitment to ensure that its platform is not misused on a larger scale to spread correct facts projected as news and designed to instigate people to commit crime. If they do not take adequate and prompt action, then the law of abatement also applies to them. It is expected that while honoring freedom of speech and expression and right to inform and educate, the mandate of Article 19 of the Constitution has to be kept in mind, and there has to be a healthy balance in overriding public interest. In addition to taking the above reinforcement of legal provision to make the platform more accountable, the government will also promote initiatives to increase awareness among the citizens to become adept in noticing fake news and to avoid becoming a party to viral circulation of fake news. A campaign to educate school children about the misuse of social media for propagation of false news will be taken up. The common service centers will also be engaged in task of promoting this message among especially in rural areas. Various stakeholders such as educational institutions, professional and industrial association, chamber of commerce, etc. will also be involved in this campaign. The state government will also be requested to join in this effort to make the citizens more aware to prevent the use and abuse of social media. In this regard, I will be writing to all the chief ministers. Conclusion. Honorable Chairman, sir, government is committed to freedom of speech and expression and privacy of citizens as enshrined in the Constitution of India. Government does not regulate content appearing on social network platforms. These social network platforms, though, are required to follow due diligence as provided in Section 79 of the Information Technology Act and the rules identified therein. They have also to follow Article 19(2) of the Constitution and ensure that their platforms are not used to commit and provoke terrorism, extremism, violence and crime. Honorable Chairman, sir, I have deliberately made the speech a little bigger because the comprehensive view can be conveyed. I will await the feedback from honorable members. Sir, let me assure this House that our government is committed to freedom. But freedom also comes with responsibility. And therefore, the social media platform, being a stakeholder, have also to understand the import, integrity and dignity of the larger message of India's Constitution so that we don't promote crime.
Right.
So with these words, I conclude, sir. I'll await further discussion.
Right, Minister. Really comprehensive. V. Muralidharan, you get 7 minutes.
Honorable Chairman, sir, the notice that I had given regarding the misuse of social media to spread fake news which leads to violence and unrest in various parts of the country. The Honorable Minister has made his statement, but I would like to further put forward some of the views that are of very important, that are the views which are very important in the present context. Of course, the government led by Narendra Modi ji has given utmost importance to the IT sector. Digital India is one of the prime motto of the government of India. E-governance, through which the citizens should get the services on demand, digital empowerment of the citizen. These are the main mottos of the government. But at the same time, I would like to
all right, that discussion there extensively, which is on in the Rajya Sabha after a very detailed statement that has been made by the Union Minister for IT, Mr. Ravishankar Prasad, and all the steps here that the government has taken to rein in rumor mongering and fake news, which is leading to cases of lynching and mob violence across the country.